Hi, I'm Nancy Schick, attorney, mediator, and conflict resolution coach in New York City. My goal is to keep you out of court and build your conflict resolution skills. This video is still regarding the Title IX changes, but it's for you attorneys because I read an article during some of my research for the course that I'm launching to help, in particular, smaller schools that don't have all the resources that large universities do. But in the research that I read an article and a quote from an attorney who, this is what he says, regarding the controversy about the live hearings that are now required under the changes that took effect on August 14th, 2020, he said, you don't want to turn every sexual assault hearing into someone towering over and berating the complainant. Yeah, and here's the thing, we really don't want to turn any hearing into that. These are very difficult cases. Sexual assault is always a challenging situation. Sexual harassment is very traumatic also, and that's what Title IX is all about. So, I found that such a strange quote because having been through both of these situations as a survivor of sexual assault and a former target of sexual harassment more than once, in both cases, I don't really want us to treat victims and targets that way and under any circumstances, nor do I think it's really necessary most of the time, especially in campus situations, that we need to berate anyone. I believe it's Ruth Bader Ginsburg said, you can disagree without being disagreeable. And I think we have an opportunity to lay a foundation for very effective, powerful conflict resolution, where we teach people how to go out into the world and resolve conflict in a much more productive way than violence and berating and destroying other people. That is not the way that we create sustainable peace. And for anybody that knows my work, that's a big goal of mine, is sustainable peace. So we presume that cross-examination technique is the right or only way. So again, this is for you attorneys. I want you to just think about, can you achieve the goal with still protecting people, regardless of which side you're on. Now, obviously, you have to talk to your clients about that and what they really want, but I'd be willing to bet most of them just want you to solve the problem. They don't necessarily need you to destroy the other side. So this is part of why I did the video that's in court sucks. I've been in court a long time. I've been a litigator, I've been a plaintiff, I've been a mediator, and I've been a witness. So I can tell you, here are your 3 tips, attorneys or advocates, because this also goes out to those of you who might be representing a student. Some small colleges allow you to bring someone of your choosing, so it doesn't actually have to be an attorney. It can be a faculty member, it can be your student advisor, it can be a friend, just so that you have that support. So if you're in that advocacy situation, 1, ask your client or the person that you're supporting what they want. I did separate videos advising both the target and the complainant and the respondent on doing this holistic approach to take care of their health. And I'm inviting you to do the same. We could all do more of this so that we're learning to deal with each other more compassionately and effectively. So second, you want to ensure that you have informed consent, meaning you want to explain to the person that you're representing what it might look like and how you might go after this particular person that's complained, or the respondent. And a lot of times we found that people don't want that at all. And that was one of the reasons for the EEO discouraging the EEOC discouraging zero tolerance policies, is because we found that a lot of the sexual harassment and sexual assault claims were underreported because of the fear of the overcompensation and berating or over disciplining the person that was involved. Because a lot of times, I think you know this, it's acquaintance rape, it's cyber stalking, it's someone that they have a personal relationship with or maybe have to see on campus or in a classroom even. So a lot of times people don't want that kind of confrontation, nor do they have a desire to destroy other people that way. So it's definitely something you want to consider and make sure that that's what your client really wants. Don't just assume it. So third, reconsider how your behavior affects the parties, the process, the profession, and society at large. We as attorneys are looked to lead. And if you're in a representative capacity, I'm going to presume you're in some sort of leadership position. So people are looking to you to set the example, whether or not you really want to be an example. So still working on that course, but I will put the link in there and you can sign up for it now and you'll get notice as soon as the course goes live. You don't have to pay anything yet. It'll just tell you, like, come do the course if you're ready to do the course on Title IX changes. In the meantime, I'm going to ask you to make choice number 6, which is to assume you know nothing about anything. Really go back to just listening anew and listening, with your third ear for those hurts you can heal, whether it's yours, the respondents, the complainants, or anyone else in the process. The more we can do that for each other, I think the more we have the ability to create more peace in society and on campus. So that's what I'm asking you to do. Thanks.